Maher versus Quincy Retirement Board.
Thank you.
Good morning, Mr. McGee.
Good morning, Your Honor. May it please the Court, I represent Ralph Maher in this matter. Ralph Maher was at one point in time, briefed if I may, the Chief Plumbing and Gas Inspector for the City of Quincy. And he and another individual, according to the findings of the District Court judge, broke and entered into the Quincy City Hall, into the personnel office, for the purpose, and by the way, at a criminal proceeding, he pled guilty to this offense, for the purpose of looking at his personnel file and taking from his personnel file material which he thought to be derogatory. Subsequently, he was indicted by a Norfolk County grand jury, and on 3 offenses he pled guilty to breaking and entering and stealing the property involved. Prior to his indictment, he had already retired. He had almost 27 years of creditable service to the city of Quincy, all the time in the area of the gas and leading up to the being the head of the department.
You make an argument in regard to the Eighth Amendment, am I right?
Yes, Your Honor. If you want to please.
Do you have any cases, I honestly don't know. Does the Eighth Amendment apply only to criminal penalties? Has it been applied in civil cases?
Yes, Your Honor. In the Austin case, the United States Supreme Court, in the Austin case, in the Alexander case, and other cases cited in those cases, they hold that it's not limited to criminal prosecutions. As a matter of fact, Judge Colvin, in his decision at the district court level, points out that in his discussion of the evolution of the Eighth Amendment in this context, points out that it was gone beyond the criminal part of aspects of it and includes civil matters and forfeitures. If I might just say that, I just want to bring back the date on this background, if I may. So he pled guilty to and the forfeiture took place, but the Quincy Retirement Board forfeited his pension, to which we brought the case to the first time of the district court. And we, among other things, we raised there the issue of the Eighth Amendment, and Judge Colvin at that time said, well, you didn't raise it before the Quincy Retirement Board, so therefore it's waived. We then went all the way up to the appeals court, and the appeals court said, look, Quincy Retirement Board had no authority to decide a constitutional question. So it was remanded back down to Judge Colvin for a hearing on that issue. In essence, what I'm arguing here is that, by the way, I'd like to say to the court that I would accept the figures in the Quincy Retirement Board's brief as to the total loss. I have an erroneous figure in my brief. It's $576,805 and some odd cents.
Not $799.
Yes, Your Honor, and I apologize.
And is the $90,000 for the health on top of that, or is that the total?
That's the total loss that he would
Okay.
incur.
Okay.
Without getting involved in any future increases in the pension, which,
Right.
and so I'm satisfied with that's the figure. When the case was before Judge Cratsley in the Superior Court, he, in response to the pleas of guilty, he placed him on unsupervised probation and fined him $500 and restitution of $393 for the damage done to
Your argument basically is, and it's certainly a very understandable argument, is that the loss of $5.5 million is just so out of proportion to the actual sentence that this man got, which was probation, unsupervised, I think, and some restitution.
But he could have gotten a 10-year sentence, right?
Absolutely, but I think it's important that Judge Cratsley, in assessing this sentence, that's how he viewed this situation.
But should it be the possible penalty, which I think is what the Quincy Retirement Board argues, rather than the penalty actually imposed?
Well, I argue,
Just because he happened to get a break from the sentencing judge maybe that isn't what should control whether the penalty is excessive.
well, my position is that based upon what Judge Kratzy did in the Superior Court, and by the way, in the transcript, which is not part of these things, but on the first go-around before the appeals court, there was an extensive sentencing hearing as to what damage was done, et cetera, et cetera, et cetera. But Judge Kratzy wound up by saying an appropriate sentence in this case is $500 fine, restitution with a door, and unsupervised probation.
Mr.
But
McGee,
I still, no matter whether you look at it from one side or the other, a loss of over $500,000, what we're really saying here is, or the board is saying, is that you can wipe away 27 years of creditable service, wipe it away for one offense that you commit
He
at age
did it.
64.
He wiped it away.
Pardon?
He did it by an
I
intentional act.
understand that. His criminal act, all by itself, wipes away 27 years of creditable service.
Does the board have the authority to impose anything less than a full forfeiture?
No.
That issue is not clear to me, and I don't think it's clear that.
I don't think they can do it, because the statute seems pretty clear.
it's sort of automatic upon
Yeah, it
conviction.
says shall forfeit
Shall forfeit.
everything.
What do you say, though, to the argument that the retirement board makes, that indeed, in the sort of public pension arena, there are cases that say the public pension, this is not a forfeiture, because it's a contingent right on
Well-
good behavior, et cetera, and so that you don't even get to the Eighth Amendment.
Well, that's the argument basically of the Attorney General in his brief. It's the argument
Also, I think the
of my
retirement
brother, Attorney Sacco, in his brief. I say, again, it's a very interesting device to use, that this was at all times a contingent pension, contingent on your good behavior for 30 years. What do we do with those 27 years of creditable service? You know, the odd part about this case is, had he gone next door to City Hall where there's a bank and held up the bank, stole $1 million, and on the way out shot 3 tellers and got life in Walpole, he'd be getting a pension. The disparity is unbelievable to me, and I look at this
Because
with biased eyes.
it was unrelated to his work.
I understand that.
But he wouldn't enjoy it very much in Walpole, would he?
Well, his wife might. But by the way, built into this loss of thing is the loss of all health benefits for him and his wife. And so they're,
Well, God only knows what possessed him to do this thing. I guess he was fearful that the new mayor might not reappoint him or something. Was that,
my own personal view, I don't know where that came from, but it's in the opinion below, and I don't know where it came from.
there was no statement in court about that when they argued for the
If you
sentence,
look-
that it was
in
a kind
the
of a
colloquy
misguided?
In the colloquy, Your Honor, between Judge Kratzley and the defendant, there was nothing along those lines.
I don't think President Nixon lost his pension because of Watergate, the Watergate burglary.
Wasn't in connection with his
He
line of
should've.
duty.
Sure was, the reelection. So query whether this man should.
You say, as a matter of fact, this is in your brief, as a matter of fact, he acquired no financial gain in the form of increased pension benefits from the action which resulted in his guilty plea. I assume you mean from the break-in action. Well, I don't understand quite how you can say that, because if he lost his job, he would have had decreased pension benefits. So from his breaking in and trying to steal the papers or whatever, he was trying to enable himself to keep his job and get increased pension benefits. So how can you say that he acquired no financial gain in the form of increased pension benefits?
Well, he'd already retired, and then when they stripped him of his pension. Now, it's been argued that the reason he retired was he was aware that he was going to get indicted. I take it. I don't know that. That's not in the record, but I assume that's what the case was.
But he broke in, as I understand it, before he retired.
Yes.
Yes.
Yeah, so that as a result of his, he sought to acquire a financial gain from his break-in. He didn't, in fact, but he sought to. If it had worked, he would have had a financial gain. That's what he was trying to get.
Well, again, I don't know from this record whether or not his plan was to get something out of that file that would prevent him from being rehired by a new mayor.
Okay.
I mean, all I know is he was working there almost 29 years over the course of a number of mayors. And
Judge Coven said this, the object of the illegal conduct was to remove documents criticizing his performance as the chief inspector of gas and plumbing to improve his chances of being reappointed by a recently elected mayor.
And you say you don't know where that came
that
from.
was not in any colloquy between Judge Kratzley and Maher's criminal attorney, Richie Egbert. As a matter of fact, the whole colloquy at the criminal case took place between Egbert and Judge Kratzley. Yeah. At the end of it, then Judge Kratzley said, do you, Maher, agree with what he just said? And that's how it went down.
There's another consideration at play, and I'm interested in what you would say about it, and that is public confidence in public officials is certainly at a very low ebb, has been for a long time. And here the people of Quincy, citizens of Quincy, I don't know, 60, 70,000 of them, how many live over there, all of a sudden see something like this and say, oh, God, they're all crooked in City Hall. They're committing crimes and all this kind of other thing. Do we take that into consideration when we look at the equity of this forfeiture?
In the proportionality argument, the answer to that question is yes, Your Honor. That's and I understand clearly the argument with regard to public trust.
Yeah, and on the other hand, I suppose the counter-argument is, well, he got caught, he confessed, he pled guilty, and he got punished. So,
it may just be the way I look at things. On October 10th, I'll be practicing now 53 years, and maybe I'm taking a different view as I get older on these things, but I see 27 years of creditable service down the drain because of one mistake.
Let me ask you this, and it really goes to Judge Coven's footnote at the end.
Excuse me, Your Honor?
It goes to Judge Coven's footnote at the end. What Judge Coven essentially says, and Justice Island and Justice Cowan have pointed to this, is that there was something in the file, I don't know what it is, we don't know what it is, that might have led a new mayor to conclude that he should not continue to be hired. If he had been successful, if your client had been successful and had escaped detection and had removed that and the new mayor had continued to hire him, according to Judge Coven, the amount that the citizens of Quincy would be paying somebody who arguably might not have been qualified or shouldn't have had the job was between $125,000, which is what he would have earned in one mayoral appointment, or $1 million if he had served out, I think it's actually his life expectancy. He'd worked until he passed away. I mean, if the thrust of the illegal conduct is to keep on the public payroll somebody who, for whatever reason, thinks if information is discovered would preclude him from being on the public payrolls, doesn't that go to the heart of Justice Glaney's question? In other words, this isn't somebody who, I don't know, did something in connection with his work. I mean, this is a lot of money that the citizens are paying him.
Whether or not he would have continued employment in the city of Quincy is another matter altogether. I doubt that very much after he pled guilty.
No, I understand that, but apparently what he was doing here, when Justice Glaney said, what on earth was he doing here, there was apparently something in his file that if an objective new mayor looked at it, would conclude, or at least your client was sufficiently concerned, would conclude this man is not qualified for the job and would not have either retained him or reappointed him or would have fired him, whichever those are.
Under those circumstances,
yeah,
had a new mayor said something like that, then Ralph Maher would have been entitled to a hearing before the new mayor could have terminated.
But wouldn't he, I mean, I don't know this, but would he, is there a difference between being the head of the department and being employed somewhere else in the department? In other words, is this a question of being out of a job, or is it a question of a demotion to something?
Out of a job.
Out of a job altogether?
A very high-paid job. 6 figures.
Pardon?
It was a high-paid job. At least if I take Judge Coven's. Well, maybe that's over the term. That's over the term.
Could you just address one question before your time is up, please? You alluded to the health insurance benefits, and the Quincy Retirement Board says that it's fair to assume that in light of his criminal convictions, he would have been terminated for cause and thus rendered ineligible for his health insurance, even if the criminal convictions didn't trigger a pension forfeiture. Do you agree? Would you comment on that?
Well, that's the point. He had, upon his termination and revocation of forfeiture of the pension, in the appendix to my brief, I note what he has to pay, he and his wife have to pay independently now for their health care coverage.
But the city is arguing that he would have been ineligible anyway because of the criminal convictions, even if the pension weren't forfeited.
If the pension were not forfeited?
Yes. That's what I.
He remained on the pension rolls, then he'd be entitled to participate in the group
the other brief
insurance
says,
plan.
although Maher retired and was not terminated by the city of Quincy, it is fair to assume that in light of his criminal convictions and the underlying facts of the case, he would have been terminated for cause and thus rendered ineligible for his health insurance.
Well, that's a correct statement, right?
So you'll agree with that. So
Right.
he would have been
He would have been
ineligible anyway. So he
terminated,
didn't
right.
really lose his health insurance. I mean, he would have lost his health insurance anyway,
Right.
even if he continued on with his pension.
If he
Okay.
was terminated for cause.
Right,
Right,
right.
okay.
One final thing, if I may, just to give you some background on this thing. Prior to any of this happening, the FBI and the United States Attorney had subpoenaed an enormous amount of records from the city of Quincy, not just concerning, and among that big sweep was Ralph Maher's records. So when he went into that room that day, and again, I'm not trying to justify what he did, to look in his file, there was already in the hands of the U.S. Attorney the complete file. And at the retirement board hearing, I said to my brother, look, let's find out from the U.S. Attorney what was taken. He's got the records that he got by subpoena.
Why is that relevant?
Well, it was important to see just what if anything, was taken.
Why does that matter? He broke in. The issue is he broke in, not what he got or
It was
didn't
relevant
get.
to me at the time as to what, if anything, was really taken. Okay, I understand the breaking in. I'm not trying to justify that, Your Honor. But all this business about taking a derogatory thing out of his file out of fear the mayor may not rehire him or something like that.
It's hypothetical.
Pardon?
It's hypothetical.
It's hypothetical. And my brother tried to get, in all fairness, he tried to get it from the U.S. Attorney and was unsuccessful. And
Well, thank you for that background, Mr. McGee.
well,
But
it's-
your time.
I've been laboring with this thing a long time and just thought it might be helpful.
Thank you very much. Mr. Sacco, could I ask you a couple of procedural questions?
Certainly, Madam Chief Justice.
Has final judgment entered in the trial court, in the district court?
On Mr. Mayor?
Yes.
Yes.
Final judgment has entered?
It's my understanding that no further appeal was taken, that the judgment is final on the criminal matter, yes.
No, on this matter, not the criminal matter.
Oh, I'm sorry, Your Honor. Yes.
Let me explain where I'm going.
Certainly.
There's no rule that provides for what the district court judge did in this case. The district court judge can't report it to the appeals court, correct? And at least as far as I can ascertain, no final an appeal from Judge Covan's ruling was taken apparently, but no final judgment had entered. So I'm having a little bit of a hard time figuring out why this case is here. I mean, I know we took it.
Actually, Your Honor, I had that conversation yesterday with the Attorney General trying to figure out how this, procedurally, that the case was reported
Well,
back to the
might he not
appeals
have
court.
had authority to report it to the appellate division of the district courts? Did you look into that? And if so, the only defect is he reported it to the wrong court, which we can ignore.
I think, quite frankly, Your Honor, we didn't look at that. I think Mr. McGee and I
Be
treated
the
this.
answer.
I'm sorry, Your Honor?
I think that might be the answer.
I would
Might.
I would agree with you that that might be the answer, Your Honor, but when you asked me if I looked into that particular issue, we did not. We treated this as an appeal taken from the district court following the remand by the appeals court, and that the final judgment was issued in that
Let me
manner.
ask you this, turning to the merits. If we rule in your favor, might not the best approach be to, there's three prongs to a forfeiture, as I understand it, under the Eighth Amendment, the last of which is the, quote, excessiveness factor. If we just assume the first two prongs apply, because frankly the law is, at least as far as I can see, very unsettled on the application of the Eighth Amendment to civil forfeiture statutes, particularly in retirement area. Certainly there's some law on, forfeiture of vehicles and that kind of stuff in connection with criminal convictions. And also skip over this whole contingent argument, namely that the pension is not a pension in terms of a forfeiture right until you actually retire, and just drill in directly to the third factor, which is excessive. And there we do have a precedent, and that's the McLean case, do we not?
We do, Your Honor.
Where there was a rather substantial forfeiture, and it was held, for the reasons you argue, among others, that it was not excessive.
We do have precedent there, Your Honor, although respectfully I would encourage the Court to address the first two prongs of the Eighth Amendment issue, because there are cases which were identified in the brief, the Hames case down in Florida and the Azar case in Rhode Island, where they did take that position that a pension forfeiture is not an extraction, drawing the distinction between, under the, hopefully I won't butcher the name, the Budget-Kajian case. The Court specifically said a fine was an extraction, and in this case, or in any pension forfeiture case, the government or the Commonwealth is not extracting anything from Mr. Maher or any individual who's a public employee who's convicted of a crime.
So therefore the Eighth Amendment doesn't apply.
And isn't that, that was my very first question, is whether the Eighth Amendment applies in these circumstances. And wouldn't that be the simplest way to resolve the case? I mean, if we want to.
Based on the cases you just cited?
It certainly would be the simplest way.
And then you bought yourself a ticket to Washington on the train.
Right, exactly.
Well, I have to say that woke me up last night thinking about that possibility.
Whereas the approach I'm suggesting keeps you in wherever you live.
But maybe he wants to go to
I would,
Washington.
Peacefully or quietly.
quite frankly, wouldn't mind going to Washington, Your Honor. But
Even if 9 people say that you are wrong?
absolutely, would be an honor, Your Honor. And
Well,
to
suppose
that-
they say you're wrong. What have you done to all these statutes in all the states that have been resting comfortably? That are probably similar to this statute.
Well, it'd be an interesting next few months, I think, following a decision like that, Your Honor. But back to the heart of the case, in terms of the fine, I do think it is important that it's not an extraction in this case, and we don't believe, and the Attorney General who filed a brief, an amicus brief, also doesn't believe that it is a fine. It is contingent upon proper service, an honorable service, which is something that the Court mentioned in the McLean case, that
If you put it on that third-prong basis, McLean, I don't think the U.S. Supreme Court would touch it.
I don't think they would either, Your Honor. And I obviously, the Board and
Be
the
purely a
Attorney
matter
General.
of, state and local governance, and under federalism principles, they would not want to get into this.
What-
Whereas
oh.
the other two prongs get you into a very thorny area about the extraction and everything else that could have collateral effects on an awful lot of other cases.
I agree with that, Your Honor. And certainly the proportionality test, I think it's clear that
Why wouldn't it be a federal question, though, since you're talking about the Eighth Amendment? Whether it is or isn't proportional?
No, I wouldn't be on the proportionality issue, just I think what Justice Greene was saying on the
Would
whether
be
or
a
not it's a
federal
fine.
question, but
That would be a
I
federal
don't think
question.
they'd bother with it. Cert would be denied.
Your Honor, I'm certainly not here looking to move past beyond this court to Washington and argue the case. I'm simply stating that in looking at what the court has said, the Supreme Court has said, in terms of whether or not a pension in forfeiture is a fine for the purposes of the Eighth Amendment, I don't think we have that in this case, because we are not extracting anything from Mr. Maher. We're simply disqualifying him for, in essence, violating the terms of the contract with the retirement system that, in the opinion of the justices in 1973, recognized that the agreement between an employee and the retirement system does create a quasi-contractual relationship. And contingent in that contractual relationship is we don't ask a lot. Our public employees, they have employment, they have a pension, they have wonderful rights, and all we ask them is to not commit a crime in violation of the laws of their position. As Mr. McGee said, Mr. Maher could have committed the exact same crime on a private residence and would still be entitled to a pension. Now, that may not sit well with the public, but that is, in fact, the way the law reads. And so there is this specific exception. In terms of the punitive nature of this particular act, in the McLean case, I think the court recognized that there are non-punitive purposes to a pension forfeiture, such as protecting the public fisc and the public trust. And I think Justice Greene mentioned that, unfortunately, these days, we cannot pick up a newspaper and not read about another public official committing some egregious act. So
What do
certainly,
we do about the Bulger case in which we said that for statutory purposes, this forfeiture provision is penal?
well, I think you just
Punitive.
well, for statutory construction purposes, I think was what the court said. So that at least my interpretation of the Bulger case.
Why wouldn't statutory construction purposes apply here?
Well, that just means that you would, you
give it a
do
narrow,
strictly
you just give it a strict,
narrowly,
narrow
yeah.
construction, not that you construe it as being penal in nature. At least I thought that's what the
I
court.
thought it's because we've construed it to be penal in nature, we then strictly construe it.
Well, that was.
Is penal different than punitive? I'm sorry.
I would agree with
this
Justice
is-
Botsford on that
Yes,
point, that I think it was.
I think that there's an argument that it is.
Penal is different than punitive.
Correct.
So I think in the McLean case, this court cited two cases from New Jersey, the Mount case and the Prince case, which talked about this type of a forfeiture is to induce honorable public service, which is why we should all go into public service. And in fact, in the California Supreme Court in the Rialva case, they said if there is a sanction in a particular statute that is designed to serve a legitimate non-penal purpose, then it's not punishment under the Eighth Amendment. So on those first two prongs of the test, I think in terms of it being a fine, which the Attorney General and the Board would suggest it is not a fine and that the Eighth Amendment would not be applicable, and even if it were, that it's not a punitive forfeiture. I would like to turn to what perhaps the Court may gravitate to in terms of the disproportionality test here. And as the Court pointed out, even though Mr. Maher's sentence was light, the three offenses of which he pled guilty could have resulted in his incarceration for 17 and a half years. The fact that the judge, as Justice Cowan said, gave Mr. Maher a break does not in any way minimize the gravity of the offense.
Aren't we really supposed to look at the offense itself as opposed to whatever
Yeah.
numbers might be nominally placed on it for the most egregious form of the offense?
Well, I believe in the Bajikagian case, Your Honor, that the Court said you look at the sentence, not at the sentence itself, but at the potential penalty for the crime committed.
Well, in essence, what we said in, I think it was McLean, which is, it's not that we look at the offense, but we take into account how seriously our elected representatives think this kind of conduct is by reference to the possible sentence. It's not that you ignore the underlying but we may think something is not so serious as somebody else, and you turn to the elected representatives, and if they think this is so serious that the possible penalty could be this great, that at least would inform me somewhat as to how serious the offense was.
Except
Yes.
that one could argue, though, that if the sentence possibility is 0 or probation to 10 years, the elected representatives are seeing that there's a large range of possible crimes that fit within it. And so if a judge has made a judgment that this is at the very low end, that's not irrelevant.
I would agree with you, Your Honor, that the judge did make a judgment, if you will, on what the appropriate sentence was. But going back to the McLean case, the maximum sentence that could have been imposed on Mr. McLean was 4 years. That was the maximum.
But I thought the basis of the McLean case, at least the excessive analysis, was that he received some $512,000 in benefits for violating the state conflict of interest law, and therefore the forfeiture of $576,000 in pension benefits surely was not disproportionate to what he received illegally.
Well, certainly that was one of the other factors of the $500,000 of benefit that Mr. McLean received through his criminal activity. But, Your Honor, if I may, I would suggest that this is more intricate than simply a financial equation, if you will, as to in terms of the loss. And it does go back to what the expectation is for our public employees. If Mr. Maher knew, and he certainly had a gain, and what Chief Justice Marshall was referencing in Justice Coven's footnote, he was making in excess of $60,000 a year. He would have had potentially 2 more years of that mayoral appointment and could have continued working, where he could have earned up to in excess of $1 million had he not committed the crime. And we can't lose sight of the fact that the only one responsible for losing his pension is Mr. Maher, because he made a decision. Most public employees who are subject to mayoral appointments may sit back and cross their fingers and hope that they get reappointed in a new administration. And if they don't, someone with Mr. Maher's service and his age will retire and make $37,000 a year for the rest of his life and have health insurance. Instead, Mr. Maher made a choice that he was going to break into City Hall, and I disagree with my brother, and it wasn't part of this case, but in the first case that went to the appeals court, and in the colloquy, there clearly was evidence and statements made that he was going in to extricate from the file unflattering documents that he felt would impact his ability to be reappointed. But we're not here to litigate that or argue that. He broke into City Hall and hoping by fraud to remove documents to secure additional employment. That, in my view, goes well beyond any kind of a financial loss. Whenever you have a pension forfeiture, you're always going to have a significant financial loss by virtue of the fact you need 20 years or be 55 to retire. Anytime you forfeit a pension, the financial loss is going to be significant. What I think is important here are the other prongs of the test. We discussed the maximum penalties. The harm resulting from the crime is incalculable, Your Honors. When I was here a few months ago on another case, and I remember driving in, listening to the radio, and someone said, the problem with the pension system is that there are 100 cops living on Cape Cod on disability making $100,000 a year laughing at all of us. There isn't one doing this work for 25 years. There isn't one that is in that situation, but that's the public perception. That's the harm. That's what needs to be prevented here, and that a public employee needs to understand that there are consequences for their actions, and those consequences are if you commit a crime in the violation of the laws applicable to your office or position, you will lose your pension. That is an appropriate remedy, Your Honors. And
So it's always proportional. If you commit a crime, that break a law that relates to your official duties, whatever the language is in that section, no matter how serious that might be, that's proportional.
Or unserious it might be.
Or unserious it might be, that's simply proportional.
I'm not asking the court to make that blanket statement that it always is. I think the harm is so significant that certainly there could be some cases where it is disproportionate. The test in this particular case, in the Supreme Court cases, as you will recall, had to do with a failure to report removing money from the country. And as a result of not making that report, he forfeited $367,000. That clearly was disproportionate. But certainly in this case, I think the harm...
Your time is up, but it could be a misdemeanor offense. And I query whether the statute would apply then. The statute doesn't differentiate between felonies and misdemeanors.
It does not, and
I mean,
Mr. McLean committed misdemeanors, was convicted of misdemeanor offenses, Your Honor.
Driven the car, if he gets a car that says plumbing inspector, and negligently been convicted of negligent operation. Query whether we'd...
But that's not this case.
That's not this case, but
yes,
there
Justice
could be a
Garland, that's
case
not this
where
case.
proportionality would be so out of whack.
Yes, there could be, and I'm certainly not asking the court to make that blanket determination. But I see my time is up, and
Thank
no
you,
other
Mr.
questions.
Sacco.
Thank you.
I'm okay.